So I welcome you to today's class, and we are going to pick off from where we stopped in our last class. For those of us who have been following us closely, work for this particular course, topic 3, which is sources of, we looked at the first one, which is the Nigeria legislation, and then we've looked at the received English law as number 2, and also we have looked at case law as one of the sources of Nigerian law. So also in our last class, we took on customary law, and then in particular, we looked at the validity test that a particular custom or norm must pass through before it can be before the court can apply it as a law in Nigeria. Now, for the purpose of just carrying everybody along, we have finished all the topic, all the discussion on customary law. And now we want to look at Islamic law as one of the sources of Nigerian law. But before I do that, I want Hello, class, can you hear me?
Yes, sir, I can hear you now.
Yes, sir, we can hear you.
Okay, I think I lost my connection for some few minutes, but I'm back now. So I was saying, I don't know if you got that part of the class where I said that we looked at the validity test for customary law, and that I want about 3 people within the class to tell us one each what they understand by the validity test that we discussed on customary law. Okay? Anyone? I hope you can hear me. Hello, class. Can you hear me?
Yes, sir.
Okay, so that means nobody wants to answer. Let's continue.
Okay, yes. Good afternoon, sir. Good afternoon, sir.
Good afternoon, sir.
Yes, sir.
I wanted to answer, but I can't even hear. I can't hear anything.
We can't hear you, sir.
Sir, your mic is muted. We can't hear you.
All right, thank you for that. I didn't know it was muted. So, like I said, no one is interested in answering that question.
Good evening, sir.
So we move on with the topic. Okay. All right. Odutayo, let's have you.
Okay, good evening, sir. So, before I answer the question on customary law, I just want to bring to your notice, so we don't have a repetition of what happened in the last class, that we've not actually treated judicial precedents in this class for IC particularly. We've not done judicial precedents, we've not done case law. In our last class, we only discussed Nigerian legislation, the Nigerian legislative process, and the received English law. And under the received English law, we discussed common law and equity. So we were supposed to start from statute of general application, going to what's it called now? Case law, judicial precedent today. But in the class you had, I think last week that we joined, we learned, we listened because we were teaching about validity of customary law. So that's when we joined the class. But like for our own class, you've not treated case law and statute of general application. But yeah, we joined the class where you were teaching about validity of customary law. And if I may, I would like to proceed to answer the question. Your mic is muted, sir. Your mic is muted, sir.
Because ever since I follow in terms of knowing where we stopped and where we started in a particular class, I've opened a diary to note the topics that I treat for each class. And I've continued in that light. I've started substitute of Nigerian law since on the 19th of March. Okay. So I have everything written down here. Maybe you missed a class where all of that was discussed. So we started the sources of law on the 19th, and then we have taken the topic consistently from then. If you recall, on Monday, the Monday class is not only for your own regular 100 level, it's both for 100 level mass comm and ICE. So that we have moved past that stage. So where we are as of today is Islamic law. I have my record here, and I'm bound by that record.
All right.
Okay. So if you want to answer the question,
Sure.
please, you can go ahead.
All right, sir. So I would like to answer that we have three validity tests for customary law. We have the repugnancy test, the compatibility test, and the public policy test. So as provided by the section 44 of the High Court Law of Oyo State of 1978, said customary law may be applicable if it is not repugnant to natural justice, equity, and good conscience, if it is not contrary to public policy, and if it is not incompatible directly or by implication with any law that has been in force at a particular time. So going by the repugnancy test, the repugnancy test simply states that a custom should not be repulsive, that is, it should not be strange, it should not be barbaric, it should not be repugnant to natural justice, equity, and good conscience. That means that because customary law basically means law that grew out of the traditions and customs peculiar to people of a particular tribe or region of Nigeria. So this law that is being practiced is common to these people, yes. But at the same time, if it is to be practiced, if it is to become a law, before it can become a law, it must go through some checks, which are the validity test, which means that it must not be repugnant to natural justice. That means it must not be disgusting, like I said. It must not be strange. It must not be abhorrent to natural justice. And then you said that, for example, in some parts of Nigeria where we have discrimination against the female child, where the female child cannot inherit her father's property, that is not good enough. That is discrimination. It is discriminatory rather. So yeah, that kind of law is repugnant to natural justice. Or some traditions where the widow has to, drink the water that is used to bathe the corpse of her dead husband. Yes, so that those kind of practices, those kind of barbaric, archaic practices, they cannot be put into law. So yeah, customary law would go through a repugnancy test to be sure that it is not against natural justice. When we say natural justice, we mean although defining natural justice is a bit tricky, but natural justice is just simply put something that is not repulsive to human beings generally, and like what they feel like is justice. Equity, we established that equity means fairness in its plain sense, and it is a rule of common law that states it is a fundamental principle that recognizes that the strict adherence of common law may not always be just, and it allows for discretion. So that customary law must not be repulsive to equity and good conscience in the simple terms. I don't think I need to explain good conscience. So yes, that is all for the repugnancy test, sir. Thank you, sir.
All right. Thank you very much, Dutayo, for that. Is there anybody in the class that is willing to discuss the two other tests? If there is no one and Dutayo is willing, please go ahead.
Okay, the compatibility test. It just simply means that it must not be incompatible directly or by implication with any law that is in force at a particular time. This is just that it must not negate an existing law. Yes, it must not, let's say a law has already been in existence, yeah, and then you want to bring customary law. Although customary law that particular customary law might have been in existence before that law even came, but because customary laws are largely unwritten, and we do not really recognize unwritten laws as laws because they are not codified. There's no writ for them, unlike the common law system that there is actually a writ. It's codified. Customary law of Nigeria was not codified in a particular constitution. So yes, this law now must
Let
not
me
negate.
correct. Largely unwritten. Largely
Yes.
unwritten.
Yeah, largely unwritten, yes. So now this customary law, this tradition peculiar to these people must not negate, like it must not go against any law that is in existence at a particular period of time. So we check for compatibility. We check if it is compatible to be brought in to be recognized as law before. But if that law now has a clash with a written law, a law that has been in existence, if that law has a clash, then it cannot work. It cannot be accepted. It cannot be accepted as law. Then the public policy test, the last but not the least, according to section 14, subsection 2 of the 1999 Nigerian Constitution, it says that public policy can mean public welfare, public good, and public interest. So any custom that is found wanting in any of the way that assaults public policy is not customary law, which means that any custom that deviates from that is not looking out for public welfare, that is not looking out for public good, that is not looking out for the interest of the public, of the members of the public, is not accepted. It cannot be accepted as customary law. And because the duties of the officials of government is to promote public welfare, to promote to promote security and bring about public welfare. Yes. So yeah, they look out for this. Even the judges, while interpreting laws, look out for this. The legislature, before they accept the law. Yeah, they look out for this. Does it promote the public good? Is it going to be of good to the general public? Is it going to be for the greater good of the society? Yeah, so they check this. If it now negates public policy, if it is not something that everybody can benefit from, or something that is going to harm society and the government greatly, it is not accepted. So these are the checks that the customary law must go through before it becomes law. And yeah, let me also note that public policy are the ideas which prevail in our society at a material time, at a particular time, at a condition that are necessary to ensure public welfare. So yes, whenever we just hear public policy, what should just be ringing at the back of our mind is public welfare, the greater good of the public. So if a law that is in custom is not is negating the principle of public policy, then no, it cannot be accepted into law. Yes. Yeah, I think that's all I know about it.
That's a good one, Odutola. Thank you very much for that beautiful rundown on the test that we've discussed as it relates to customary law. So in moving forward, we are going to look at Islamic law as customary law, even though we are sources of see that there are situations where we refer to customary law as, Islamic law as customary law, but in that we're going to, correct that kind of notion in the course of this class to show that Islamic law is not customary law, but it may have been tagged as customary law for the reasons that will be revealed in the course of this class. Please just give me
Sir, you're muted.
hello, class. So now, we are going to start by looking at the essential characteristics of customary law. And when we pick the characteristics, that will give us the understanding of what Islamic law is and whether or not it's falls as a customary law will also be discussed along the same line. So the number one point we are going to raise and establish about Islamic law is that it governs basically the lives of Muslims, meaning that it is a religious law. That's number one thing we need to know, that customary law governs basically the lives, that is the activities of Muslim. And then on that note, one can classify it as a religious law. But one of the things we need to take to our mind is that the purpose of looking at Islamic law as a source of law is not to classify it as either a customary law or a religious law, but rather to be able to show how the law, the Islamic law as a body, has influenced our legal system or people. So I will mention the first characteristics. We move on to say further that it is the law that regulates the Muslims' interaction with non-Muslims. And then this particular class of law preaches against man-made laws and gave divine-made laws as alternative. Now, if we begin to look at that statement, you may take your mind to when we're talking about natural law as an aspect of law, and when we're looking at it alongside with other classes as it relates to maybe positive law and the rest, we were saying that yes, natural law are laws put in place by nature, and that they are not products of man or any form of government. So to further establish that fact, when we talk about Islamic law too, one may be tempted to see it in that light, but available literature on it suggests or made us to understand that it preaches against man-made laws. And of course, there will be reasons why that is so. And it cannot be far from the fact that because of the nature of man, man is not perfect enough to make law that we be free of every form of criticism. For example, if I ask the class coordinator of this class now to make law, he or she is probably going to make law that will not in any way affect him or a group of friends. And that's human being. For Islamic law preaches against man-made law and gave divine-made law as an alternative, in that if it is a law made by God, such law will be perfect. It will not be a kind of law that is made for the interest of one as against the other, meaning that it will be a law that is fair enough to meet every need within the society, irrespective of sex, gender, or race, or whatever, whether color of skin, and so on and so forth. Now, it is also good for us to know that this class of law is seen as a law made Hello, can you all hear me? The network here is kind of terrible.
Yes, sir, we can hear you.
It's taking me off and on. Can you hear me now?
Yes, sir. I can hear you.
Okay. All right. Thank you very much. So there is an explicit emphasis that Allah, the maker, is a lawmaker and also the lawgiver. And that a Muslim state is just a trustee, that is one who holds the law, is the lawmaker. So basically, in discussing Islamic law, one, we can establish that it is not customary law by virtue of the fact that it's Muslim, and from the other discussions we've had, we've been able to establish that Allah is the lawgiver and is the lawmaker who only gave the Muslim the right to hold the law as a trustee. And then where is Islamic law derived from? We see that Islamic law is largely derived from written sources like the Quran, the Hadith, which is sometimes known as Sunnah, as in Sunna. Okay, so the sources of Islamic law are number one, Quran, Hadith, and Ijma, as spelled as IJMA. And then the last one is Qiyas. Even though people of Islamic faith may pronounce it in a different way than the pronunciation that I've given. But when we want to determine the source or the sources of Islamic law, we refer to Quran, which is spelled Quran. We also refer to DITH. We also refer to Ijma, which is IJMA. And lastly, Qiyas, QIYAS. All of these are the sources of Islamic law. And so if you are saying that Islamic law is one of the sources of our laws in the society, is part of it is gotten from the Islamic law. And of course, it is true because the Islamic law, as we will see later in the course of this class. Now, the characteristics. Okay, I think I should clarify, or for the purpose of those who are not, the benefit of those who are not Muslims, the hadith is a kind of behavior derived from the life and conduct of Prophet Muhammad, meaning that, the ways of life of the Holy Prophet has become some sort of law or direction as to how the society, how human beings should live, and consequently, those can be, listed or itemized to mean rules and regulation about different things. And then, of course, different things as it relates to different aspects of our lives. And then the Ijma scholars, there are Islamic scholars who, by virtue of their scholarship, they've been able to advance a lot of rules, regulations, or knowledge to, which of course forms the rules and regulation, which also govern the society, and then which consequently can also be said to be one of the sources of the Islamic law. Okay, so when we look at Islamic law and customary law side by side, we will discover that the two of them are two different systems, because one focuses mainly on religion, while the other one is its major concern is custom. So, and that's why when we want to, put the two side by side, we will say that the two systems can be classified differently. But also, if we, look deeply, one may also be tempted to say that the Islamic law is also part of customary law. Although many literatures, have made that as a form of assertion and to say that the Islamic law is a customary law. But the truth of the matter is that from the characteristic features that we have seen, Islamic law should not be classified as customary law. I will advance some reasons in order to buttress this point in a short while. Please just give me 1 second to check. Okay, so what are these reasons? Number one is that it was the colonial masters in their attempt to fight the Islamic law in Nigeria that tagged customary law, Islamic law as customary law. Now, what are we saying in this sense? One of the things that the colonial masters or those who colonized us did when they got into our system was to first of all make the our available laws, rules, custom to become an inferior law. Is to make every other law apart from theirs as inferior law. So one of the things they try to do how they can relegate to, they classified it, not even try to, they classify Islamic law as a customary law. And that was done by virtue of Section 2 of the Native Court Ordinance of 1914. That was the law that classified Islamic law as a customary law. Then also, another reason why we cannot classify Islamic law as customary law is because number one, we have said that the colonial masters made an attempt to make the law a lesser law. And then to now worsen the situation, there was this deliberate error in the provision of Section 2 of the old Native Court law.
Sir, your network is breaking, so.
No.
The network is very bad.
Hello, hope you can hear me. I think I was logged out again, but I'm back now. Hello, class.
Hello, sir.
Yes,
Hello,
Can you
sir.
hear me?
Yes.
All right. All right. Thank you very much for the confirmation. So I said what the second thing that further worsen this position we are trying
Sir, please
to
excuse. Sir, we didn't get the first one.
is that the first one is the attempt by the colonial masters to directly tag the customary law, Islamic law, as customary law. And they did that by virtue of Section 2 of the Native Court Ordinance of 1914. That was the first thing that possibly that is, majorly makes the customary law, Islamic law, to be addressed as a customary law. Okay, and the second one, which I was interjection, was that there was an error in Section 2 of the old Native Court Law of the Northern 6. And what happened in that provision is that the provision was, Islamic law was included as part of native law and custom. Okay? Why in 1914 classify Islamic law
The line is breaking, sir.
as customary law? Under Section 2 also, other sections of the Northern Region, number 6 of 1956. In that law, Islamic law was classified as part of native law and custom. So, in that place, sorry, I got muted again. So, there was that inclusion, direct inclusion of Islamic law as parts of native law and custom. So, of course, that's now gave Islamic law some form of a name like the indigenous customary law, of course, which is not so. So, but from the characteristics of this law that we have seen, we can now on our own agree in this class that Islamic law is not a customary law, because you may have seen it in some books or literature stating that. Of course, there's need to clarify that so that when we are dealing with, as we are dealing with Islamic law as a source of Nigerian law, we are able to see it as an independent law and not a law subsumed into customary law. Yes, David Odumosu, you have a question?
Yes, sir. Good afternoon, sir.
Good afternoon.
Sir,
Go ahead.
so I saw a question one time when I was going through my past question, and the question said, let me, I want to be able to see the question when I'm able to see it directly. It said, when would a customary law be applicable to a Cameroon citizen in which region in Nigeria would a customary law be applicable to a Cameroon person in Nigeria? So the options were northern, western, eastern, and southern. So the word customary there actually made the question a little bit hard to attempt based on some this. I don't really now know what the answer would be based on the word customary used there.
Well, from the law that I've quoted for you, which is the whole native court law of Northern Region, number 6 of 1956, you will see that in the North, customary law Islamic law is referred to as customary law. Do you get that? So, even though we are
Yes, sir.
saying that it was an erroneous inclusion, because we are studying, we need to put our mind to that. We cannot say because actually Islamic law is not customary, then we now forget some of the errors that have been committed. Ordinarily, if we are to do it that way, we will not be taking so much effort to explain what customary law. All we just need to do is that sources of Nigerian law include the following, and then we will list it. But because of the need for us to know the intricacies of what we are talking about, that's why we have to delve into how it was initially referred to as customary law. Because whether we like it or not, these laws that we have mentioned, that is the Native Court Ordinance of 1914, the Old Native Court Law of the Northern Region, number 6, 1956, all of those laws are still in existence somewhere. So if you see a question like that, the answer will be the northern part. That is, if the Cameroonian is resident in the north, where ordinarily it is referred to as customary law. In the south or in the west, it's not seen as a customary law. We identify it and isolate it as a unique source of law on its own. Is that taking?
Please, sir, can you come again?
All that I've been saying, you were not listening. What do I need to come again?
No, I get the last part. The last part you said that it to be identified. The part before that time, your network kind of.
Okay, so I said
there
is likelihood to refer to it as customary law in the northern part because of the existence of those laws, even though one of them was made in bad faith and the other one was made in error to have included Islamic law as native law and custom. And that's why I said, looking at that question, the answer will be northern region. And now gave an instance that in the south or southern part here, we do not refer to Islamic law as customary law. We see it as an independent class of law on its own. Do you understand now? David, do you understand now? All right, Daniel, you are raising your hand. Can anybody hear me?
Yes, I can hear you, sir. Good afternoon, sir.
Okay, Daniel, go ahead with your question.
Yes, sir. The number 2 point that you listed, you said there was an error in the old native court law of the northern region. Is that all for the number 2 point, sir?
Yes. What I said is that there was a deliberate error in that provision, especially in section 2 of the old native court law of the northern region, number 6 of 1956. And I said, under that provision, Islamic law was included as part of the expression native law and custom. Because it's included in that light, it's classified as customary law, but of course, it is not. So, in moving forward, therefore, what we can see from what we have been saying is that the customary law and Islamic law both run in different channels. One is religious and the other is customary or traditional. And if by virtue of this study, you apply your mind to that fact that Islamic law is purely a different law, which is different from custom, from tradition, you will see it in the light that Islamic law is a different class of its own. Okay? Now, also, it is also observed that one is more rigid than the other. Islamic law is written, and because it's written, it enjoys that rigidity character of a law. Why customary law is not a rigid law. That is, it's not a system of law that is rigid. Please, can I have just a second? Hello, class. So, as I was saying, we can see that because for those of us that followed closely, when we were talking about customary law, we identified the characteristics of customary law. And one of it is the fact that it is a very flexible system of law. And that, of course, meaning that because it's not written, it can be manipulated or it can be changed to harmonize a lot of things. But Islamic law is not seen in that light because of the fact that it's not something you can just wake up and say you want to change. Okay, so that's one other thing that we need to note about these two classes of law that we have seen. Okay, one is rigid, the other one is flexible. So that further buttresses the fact that it cannot be classified as one, as that is that Islamic law cannot be classified as customary. Okay, so then Islamic law is more rigid, unlike the indigenous customary law that is very flexible and acceptable to any social trend in vogue. You know, I said that before, you know, like before, when somebody wants to get married, the requirement is that, oh, you need to go meet the family, then you do this, you do that, and all of that. These days, okay, let me even, I may not be completely wrong, right about this. I understand that with the Igbo people, when they want to have their traditional marriage, the best of it is the one done within their community. Just like, you know, that an Igbo lady wants to get married in Lagos, will not do it here. I don't know how true that is, that the real Igbo traditional marriage is the one done in the village, either the village of the father, where the elders can be, you know, be present to observe the proceedings, supervise the proceedings, and ensure that everything is done in line with custom. But these days, you discover that it may even be that it is the husband that will tell the family of the wife to say, I can't go to the east to want me to marry your daughter. You have to do it here in Lagos. And that was why recently in the particular societal wedding that took place, and then people were saying that, is it because, hello class, hope you can hear me.
Yes, sir, we can hear you.
Yes, sir.
we can hear you.
Okay. So there
Yes,
was
sir.
a lot of uproar in the society that, is it because these people are rich, that's why this lady did not take them to their village to go and do this. Now, it's not necessarily because they are rich. It is because naturally now a lot of things are changing. Just the way those things are changing, it's not so with Islamic law, because you cannot wake up tomorrow now and begin to manipulate the Quran. Just like the way the Bible is written, you cannot wake up tomorrow and say, okay, we don't want to do this one again, because they are already written, codified, which are specific way of doing things. So that's one of the things to also justify that Islamic law is not customary law. Then on the very last note, I'll refer you to the case of Alkamawa. It's spelled Alkamawa. Alkamawa versus Asambelo and another. That is the name of the case. Now, the court says something about this, what we are discussing this evening. What their lordship, the court, said in this matter is that Islamic law is not the same as customary law, as it does not belong to any particular tribe. Now, it is the Quran that is used here in Lagos. It is the same Quran that is used in Kano. I'm not aware there is any different Quran, so to speak. Or even when you look at the other sources of Islamic law, like the Qiyas, Sunnah, Ijma, Hadith, and so on and so forth, one of the things you will discover is that there are constant, sources of Islamic law. Whereas the customary law of Lagos people and cannot or are not practiced or cannot be the same with what they practice in Kano. So that's why the court maintained in that case of Akamawa versus Asambelo that Islamic law is not the same as customary law, because the Islamic law does not belong to a particular tribe, whereas customary law differs from tribe to tribe, from community to community, and then Islamic law has a more unified system in that it is the same everywhere. Okay, so that is all about Islamic law as a source of Nigerian law. And the major takeaway from this is that the Islamic law is not customary law, is an independent system of law which has its sources from the Quran, the Ijma, Qiyas, the Sunnah, and other sources. And then it is a unified system of law, meaning that it is not in any way different from what is practiced in other Islamic states or where Islamic law is practiced, unlike the customary law, which differs from community to community, from society to society, and so on and so forth. I don't know if there's any question before we move on to the next topic, which is international law, as a source of Nigerian law. Can we take question if there is any? Yes, Udutayo, let's have you.
Okay, sir. So, when reading about the historical development of the Nigerian legal system, I got to a point, I think in the post-colonial era, that the criminal jurisdiction was removed from customary law, whereby I think the decree stated that no person was to be convicted of an offense unless the offense is defined by a written law and the penalty is prescribed by a written law, because customary law was unwritten. So I just want to be sure, since we have established that Islamic law is not customary law, I just want to be sure that criminal Islamic law, right, Sharia law still has criminal jurisdiction and it was not removed because it wasn't customary law. It's not customary law, right?
Okay, let me start from this angle so that it will give you a clearer understanding. From the provision that you quoted, you said that no one shall be tried except that crime is defined in a written law, right?
Yes, sir.
Now,
Yeah,
customary law, by virtue of what we've said, is not written. So that was one of the grounds for the removal. Because if it is not written, and then it means that it can easily be manipulated. But when a law is written, law related to crime is written, the law usually will provide for what constitutes that crime. It will specify the punishment. But where it is not written, it is open to abuse and arbitrary use. For example, the law on stealing talks about what constitutes stealing. If you take anybody's property with the intention to deprive the person of the property in that thing, the law says that that is stealing. The law also says that if you move an object from point A to B without the consent of that person, it also means stealing based on the element of the crime of stealing. So, but that criminal jurisdiction was removed from customary law because of the fact that customary law is not written, and basically it's to prevent arbitrary. So in
can't hear you, sir.
Sharia law, you said what?
we can hear you, sir. Please go on.
So in Sharia law is written. That's because it's Islamic law. It's largely unwritten, and those provisions are there. When it has to do with penal sanctions or penal law, which is law of punishment, law of crime, all of those things are written there, unlike the customary law that is largely unwritten. Are you okay with that now?
Yes, sir. Thank you very much, sir.
All right, Daniel. Olajire.
Yes, sir.
Yes, you have a question.
Yes, sir. I want to ask that the example that you gave for Akama versus Bello, is it the one that
Can you speak up a little bit?
The case that you mentioned, the example that you said, Akama versus Bello, is it the one that happened in 1998?
I don't have the citation at the moment, but if the name of the case that you have is Hakama versus Hassan Bello and others, then it may be, but I do not have the citation as I speak now. Okay?
Okay, sir.
All right. So, is that all the question we have for Islamic law as a source of Nigerian law? If that be the case, we move on to the other sources of Nigerian law, which is international law. Though we may not be able
I
to
have a
finish it
question.
before we close this class, but let's just try. Yes. Oreoluwa.
Sir, just like the way customary law has a court and the way the other laws have their own courts, does Islamic law also have courts?
There is Sharia court. That's Islamic court.
Okay, sir. Thank you, sir.
You're welcome. Okay, so let's move to international law. Now, international law is one of the sources of Nigerian law. Now, you know by chance or by way of deliberate effort that Nigeria is a member of several international organizations. For example, the United Nations, African Union, Commonwealth of Nations, and so on and so forth. And due to the membership in these several international organizations, Nigeria is a signatory or has become signatories to various international conventions or treaties. Sometimes it can also be called accord or agreement, simply put. So, by virtue of the nation being a signatory to those international conventions or treaties, it's one way or the other, as you know, imposed on itself the obligation to obey those laws, okay, or those agreements, convention, or treaties, as the case may be. And then once that particular situation takes place where Nigeria happens to sign a particular convention, a particular foreign agreement, there is a way the system adopts such conventions or agreement to be part of our laws here in Nigeria. So, but for international conventions to have force of law in Nigeria, that is to become law, such laws, such customs, such treaties, such accord, or such agreement is expected to be domesticated or ratified by the National Assembly, being the body that is saddled with the responsibilities of making law. And just to simplify it, domestication or ratification of law simply talks about the formal process of admitting that law, that foreign law that were not made by our the legislature in Nigeria, as one of the laws that govern our affair here in Nigeria. For example, we have various international instruments that talks about human rights, which is one of the major focus of the international community. No matter how sovereign or how independent this carnage can stop, and how the people of Nigeria can enjoy their rights and live like normal citizens in the country. So the international community became interested. Okay, so that's because Nigeria is part of some agreement treaties that has to do with human rights. So, but usually the National Assembly is expected to ratify the law Either, of course, they may not follow the strict process of lawmaking, but they may engage an abridged form in order to formally accept the law into our system as a country. And that is because the section, a particular section of the Constitution, which is section 12, sub 1 of the Constitution of Federal Republic of Nigeria 1999 as amended, provides in this form, okay? And I quote, section 12, sub 1 of the Constitution of Federal Republic of Nigeria 1999 as amended provides, and I quote, the law says that no treaty between the Federation, that is Nigeria, and any other country shall have the force of law except to the extent to which any such treaty has been enacted into law by the National Assembly. So what that law is saying, section 12 sub 1 of the Constitution is saying, is that before any foreign law, any international law, any international agreement or treaty or accord can have binding effect here in Nigeria, it must be enacted into law by the arm of government in Nigeria that is saddled with the responsibility of law making. Okay, so that is it. So that means once Nigeria becomes a signatory to any law and the National Assembly ratifies the law, and it becomes part of our system. And that's why in our today Nigeria, there are several international agreements that is also binding us as a people, even though those laws were not originally made or enacted by the National Assembly. Now, going forward, under international law, a treaty is any legally binding agreement between states. So that's just by way of defining what we mean by a treaty. A treaty is any legally binding agreement between two states. And then a treaty is a binding agreement between nation states that forms the basis for international law. It is that agreement between the parties, between the states, that forms what is now referred to as international law. Okay, so that is the foundation to it. And then, in order to further simplify what we are talking about, a treaty can also be referred to as a convention. It can also be referred to as a protocol. It can also be referred to as a pact, as a P-A-C-T. A treaty can also be referred to as an accord. That's why, since I started discussing convention, I've used the word agreement to replace it. I've used the word accord to replace it. I've used the word pact or protocol to replace or interchangeably. So, but it is the content of the agreement that matters and not the name. So therefore, any international body, maybe the United Nations, can choose to use the word pact, can choose to use the word convention, can choose to use the word treaty, can even choose to use the word law. All boils down to the same thing. It is not the name, but the content of the law that is of importance to us in this matter. But why we have to raise it is because in your exam, you may see agreement, accord, and so on and so forth, and ask you to identify the one that does not belong to the group. Okay? Now, but the bottom line is that when conventions are signed between two nations, it becomes an international agreement. And then authority for the enforcement of this treaty is provided by each signing party and then they have to adhere strictly by it. Meaning that once they have written it, they are bound to obey. And when they don't obey, the law usually provide penalty or sanction for it. So we talk about international law as a source of Nigerian law. Okay, and like I've said that other different names can be used to represent that. Okay, and then this same convention or international law can also be referred to as custom, and then that is also what forms the body of international law that we refer to as a source of Nigerian law. Once the states have agreed to be bound by the provision of the treaty or the accord, automatically it becomes part of the law that we govern their affairs, especially when the lawmaking body of that nation must have ratified it and classified it into law. Okay, so with that, we have come to the end of today's lecture, having looked at Islamic law, international law as sources of Nigerian law. And I want you to go and read the last sources of Nigerian law that we listed earlier, which is Opinion of Jurists and Legal Writer. You go and read that up on your own and see how the opinion of jurists and legal writers amount to a source of Nigerian law. So when we meet next time, by the grace of God, we are going to start with interpretation of statutes. But I still have like a few minutes left. If you have any question based on the topics we have discussed, you are free to ask. Yes, Abdul Salam.
Good evening, sir.
Good evening.
Sir, I want to ask, how does international law deals with country that refuses to follow international agreements?
Okay. In every agreement, they also provide sanctions, which can also mean punishments. And this can be in different forms. Number one is that they may not get aid, support from international community. Many countries still get aid, that is support, either financial support, material support from other states. Another thing is that they may not also identify with them or deal with them. Look at the countries that are presently governed by military now. They pulled out from the other bodies like United Nations, African Union, and so on and so forth, because they are no longer following democratic rule. So sometimes it may be the international body that will remove the country and said, we are not dealing with you. And you know that there's no nation that can succeed in isolation. So if they remove them, they are going to suffer some damage, some losses, in that they may not get support. Then somehow they can impose trade sanction on them. If Nigeria is cutting ties with Ghana, Nigeria will say no Ghana product comes into Nigeria. Or the international body will say, since Mexico has decided to do this, and then it failed to obey this, abide by this agreement, we are not going to allow our goods to go into their country. Automatically, what will happen is that those set of goods will become scarce in that country, and it will bring hardship on them. And once there is hardship, the citizens are bound to complain And when they complain, sometimes it leads to riot, and then the government, they feel it for it and see how they can retrace their step so that life can continue. So those are the various methods that the nation, that the international world uses in enforcing the agreement when it is made. Okay?
Thanks,
Now,
sir.
before I will take Odutayo, I have some questions in the question and answer part. One says, if a customary law passes like 2 of the tests, but not the last one, can it be modified or will it be strictly rejected by the court? The rule is that it must survive those tests. Okay? It must survive those tests. If it is not repugnant, it is not incompatible, and it's against public policy, the custom cannot stand. Then one says, I'm sorry, sir, I don't understand the last one you said. I don't know what the person meant by last one. Then another question says, sir, I want to ask, for example, in our exam, if I decided to go with some scholars that believe that Islamic law should be regarded as customary law and provide solid point to buttress it the way you are doing, will you consider it? I will consider it if your points are valid. Because somebody can be saying what is wrong and will be using boldness to say it. Somebody can be telling a lie and is saying it as if it's the truth. That doesn't make it the truth. But the good thing about academics is that you are also entitled to your opinion. As a matter of fact, in law, when you answer law questions, especially if it's a written test, you don't need to agree with the lecturer. But sometimes it's just that it doesn't, don't let me say that part. You don't need to agree if you have a higher view. There's nothing wrong in a student knowing more than the lecturer. The lecturer is not God after all. So a student might have, probably if I have a professor of political science in my class now listening to this course, there are aspects of my teaching that he will know more than me. And then if he can make serious argument in the course of the exam, so be it. He will get his marks. Okay? All right, so I think I've been able to answer the question. Then there's one here. Sir, can Islamic law be classified as eternal law like Mosaic law? Says it's a commandment from Allah. Yes, in some form it can be so. Then the last one here is that can a non-Muslim be subjected to Islamic law in a court case, especially in the northern Nigeria? If the individual is there and he has decided to be governed by Islamic law, he will be banned by it, even though originally is not a Muslim. Okay, Odutayo, let me take 1 minute to answer your question, then we can call it a day.
Yes, good evening, sir. So I just want to ask that the international law, is it binding on our law, on our legal system, or is it persuasive? Is it just something that, you said that it's after it is ratified and domesticated that it becomes a binding force, or a court might rely on international treaty to guide their decisions. So I want to know if it is binding or if it is just a persuasive.
Yeah, once it is ratified, it is binding. Okay? But its application within Nigeria, in some cases, can only serve as a persuasive authority. Okay? Especially if it is something that does not completely align with our system. Though it aligns but not completely aligned, it can be used to correct or to manage a particular situation. So it can both be binding and persuasive depending on the circumstances. Okay?
Yeah. Yes, sir. And also, sir, please, I just want you to answer this question. The last source of law, because I read up on it, the opinions of jurists and legal writers. Is it a binding precedent or a persuasive precedent?
You can ask that question in our next class, because I will be asking people to tell me what they have read. I have my answer, but ask it in the next class so that, because suppose you have read it or you have listened to my lecture on it, so you have a foreknowledge. So let everybody go and read it. When we are discussing it, then I will answer your question. Remind me. Lastly,
All right.
Cynthia. Cynthia.
Okay, sir. Sir, good evening, sir.
Good evening.
Yes, sir. Concerning one of the questions that you answered, I also want to ask a question under it. And the question goes like this, sir. Why is it necessary for customary law to pass the incompatibility and public policy test?
Odutayo, answer that question.
Cynthia, yes. So customary, can you hear me?
Yes, I can hear you.
So customary law has to pass through the validity test so that it does not because if it doesn't pass through the validity test, it will not be applicable. And also is to enable the custom. I'm sorry, my thoughts are not organized. Yes,
let me
okay,
help
yes.
you.
Yeah, it's to enable to make sure that the customs are not does not negate the natural justice, equity, and good conscience. Yes, and the compatibility test is, you said compatibility test, right? We said that it must not be incompatible to any written law. That means it must not negate any written law. We said that customary law are unwritten laws. So it's just like you saying that you are bringing in something that is not stable, because one of the characteristics of customary law is that it is dynamic. You're not bringing in something that is not stable over something that is stable, because written laws that have a writ, they are stable. You can always go back to them. That's why we have case law, we have statutes. You can always go back to them and use them in cases with similar facts. So now imagine bringing something that is shaky, something that is not stable, over something that is stable. So which one do you think would hold more ground? And also, written laws are laws that are generally that they are for everybody, general public, and customary laws are laws that are peculiar to people of a particular region. So yeah, do you get it?
Okay. Yeah, I get, but I also want to ask, do you feel like now, like in this 21st century, do you feel customary law is more like effective? Because there's a case that I read, one if I can remember, it's one case in Anambra State, one Mojuku case, whereby the case is concerning when a man dies without a male child, his property is inherited by his male relative, like his brothers or nephews, right? Okay. Then he had a daughter, he died, leaving his only daughter, and whereby the families of this man tried to like inherit this property. And what I read there was that the girl actually fought, like the girl fought this case in court. And I feel the case was in her justice, like they I don't know how to like explain it, but it was in her favor.
All right, Cynthia, let me help you. Odutayo, when you finish this class, go and eat. It's like you're hungry. Okay. So let me add to the explanation that Odutayo did. Even though when she started, she was not in line, but she got herself at the point. Now, the origin of validity test when it comes to customary law is that some of our customs can be tagged customs that are disgusting. That's the word we use. Abhorrent. That is, things that ordinarily should not be. For example, we gave example as it relates to killing of twins. He said today, twin children are beautiful children that everybody practically want to have. But at the time, it was considered as evil. So when it was happening then, when the twin kids are born, usually they kill them. So there are also customs like that. I gave an example of a female child not being able to inherit the property of the father. I said, what makes a male child better than a female child? that custom is discriminatory. So the purpose of any custom passing through that test is to be sure that the application will not bring injustice to anyone. Like the case you cited, I don't know the fact of the case, but from what you said in Anambra, yeah, that if a father dies and then he died without having male children, that the properties are inherited by the male children, male family members. That there are decided cases now that a female child or female children can now inherit the properties of their father. So that one can no longer work in Nigeria as of today. Okay?
Okay, sir.
Because that law, that custom has been invalidated by series of court judgment that now recognizes the right of the female child to inherit the property of her deceased father. Okay?
Okay, sir.
All right, thank you very much for the class. That's been very interactive and I think I enjoyed it. Enjoy the rest of your day, and as you prepare for your test, please read wide and read everything that we have been discussing, and the exam is also very close. All right, thank you very much and enjoy the rest of your day. Bye.
Thank you, sir.
Personal income,
Thank you, sir.